unemployment insurance eligibility in the case of labor disputes and to declare an emergency.
Senator Unruh.
Mr. President, House Bill 1112 addresses two job service related items. The first, in Section 1, relates to lien filing. The proposed changes today would simply allow Job Service North Dakota to file liens with the Secretary of State's office rather than only with a county recorder. This would allow a single lien filing to be effective in all counties within North Dakota. This is a service that is rarely utilized, but would save significant staff time when going through the process, allowing Job Service to more effectively and efficiently administer their unemployment insurance program with their expanding workload. We heard the amendment for Section 2 yesterday. The amendment is the bill. It clears up an ambiguous section of the code stating that workers unemployed as a result of a labor dispute are disqualified from receiving unemployment benefits going forward. This section defines a labor dispute as a strike, sympathy strike, or lockout, and clarifies the original intent of the law. This section does not take away anyone's benefits that are currently owed and is not retroactive. This change would only apply to cases going forward. Voting yes today would allow the state to remain neutral in labor disputes and uphold our right to work philosophy. Your Industry, Business, and Labor Committee voted 5-2 on this issue and urges a due pass on House Bill 1112.
Senator Murphy.
Mr. President, I was surprised yesterday speaking to a couple of senators after the session. They said they voted for the amendment on locked out people not being able to be compensed with unemployment insurance because they didn't want to take sides in the dispute. I frankly don't understand that. Voting for locked out workers to receive unemployment compensation is no more taking sides in a labor dispute than myself opening the door, as I did yesterday at a store, for a wheelchair-bound veteran. Because I opened the door for that veteran and helped him doesn't mean I approved or disapproved of the war that disabled him. As far as the rest of the bill goes, it's a simple matter of Job Service being able to collect and put liens on in 53 different counties. They've done it this way for a long, long time. I would hope that someday we could get them the consolidated way of doing it rather than 53 different county auditors, but they can do this for a couple more years because the amendment to me is much more important, and I'm going to urge everyone for humanitarian reasons to vote no on this bill.
Senator Sinner.
Mr. President, I have a question for the carrier.
State your question, please.
Mr. President, I'd like the carrier to answer the question as to what is a lockout, who defines a lockout, and when is a lockout determined?
Senator Unruh, do you wish to answer the question?
Yes, Mr. President, thank you. I'll try to address that question as best I can. A lockout has been described in the code as a labor dispute and is determined by the companies and the workers involved with the labor dispute, and at the time of issuing unemployment benefits or not by Job Service.
Further discussion. Senator Mathern.
Thank you, Mr. President, and colleagues of the Senate. I would ask us to defeat this bill for 3 reasons. Reason number 1, I believe passage of the bill in this process is a misuse of our legislative process. This is taking a major public policy issue, creating an amendment with it, not a separate bill, creating an amendment and tacking it onto a minor change of activity of an agency. This is contrary to our history in the Senate. Number two, I ask you to vote no on this bill because passing this bill gives the trump card to one side of the management-employee negotiation process. Giving the trump card is putting state government into the middle of something that should be left in the private sector. I ask you to vote no for the third reason, and that is passage of this bill, I believe, sets in motion a process contrary to well-established worldwide values and resolutions that say workers have the right to organize to support themselves and their families. This bill is very important. I ask you to vote no.
Senator Schneider.
Well, Mr. President, we had a pointed debate yesterday on the sixth order in consideration of the amendments, and I had another good run at it today. And so I don't intend to relitigate any of those issues that have been discussed so eloquently by my friend from Portland and my friend behind me from Fargo. But now that we're on the bill itself, I do want to be clear in what we're doing in this branch of government if we pass this legislation. And I also want to be clear in terms of what we should not do as we consider this legislation. As you know, Mr. President, we operate in a system that's founded on separation of powers. The North Dakota Supreme Court, as we all know, recently considered the section of the code that this bill now seeks to change and concluded that the code permitted locked-out workers to receive unemployment insurance benefits. So that's the law, Mr. President. Yet I've heard some of my colleagues say that the court was specifically requesting that the legislature clarify the law. Mr. President, that is erroneous. It is untrue. It is completely false under any fair reading of the court's opinion. Let me just provide the court's holding very briefly, Mr. President. This is a quote. The legislative history of NDCC section 520602, parenthetical 4, supports this court's interpretation that a claimant's work stoppage dispute of any kind does not include a lockout. Close quote. Mr. President, that's Well, Mr. President, we had a pointed debate yesterday on the sixth order in consideration of the amendments, and I had another good run at it today. And so I don't intend to relitigate any of those issues that have been discussed so eloquently by my friend from Portland and my friend behind me from Fargo. But now that we're on the bill itself, I do want to be clear in what we're doing in this branch of government if we pass this legislation. And I also want to be clear in terms of what we should not do as we consider this legislation. As you know, Mr. President, we operate in a system that's founded on separation of powers. The North Dakota Supreme Court, as we all know, recently considered the section of the code that this bill now seeks to change and concluded that the code permitted locked-out workers to receive unemployment insurance benefits. So that's the law, Mr. President. Yet I've heard some of my colleagues say that the court was specifically requesting that the legislature clarify the law. Mr. President, that is erroneous. It is untrue. It is completely false under any fair reading of the court's opinion. Let me just provide the court's holding very briefly, Mr. President. This is a quote. The legislative history of NDCC section 520602, parenthetical 4, supports this court's interpretation that a claimant's work stoppage dispute of any kind does not include a lockout. Close quote. Mr. President, that's not a request for clarification. That is a conclusion of law. It is, in fact, the law. Yes, Mr. President, we are free to change the law going forward. There's no question about that. The Supreme Court recognizes that is our prerogative as a legislature. But we as legislators need to realize that an opinion handed down from a co-equal branch of government shouldn't be mischaracterized as a request for us to tell that branch how to read a statute. I also heard it said that this court's decision is on appeal. Again, Mr. President, there's no shred of truth to that. What is actually happening from a procedural standpoint is what's called a petition for rehearing. As the court's own appellate practice procedures note, those petitions are rarely granted, and petitioners are required to state with particularity each point of law or fact that the petitioner believes the court has overlooked or misapprehended. It's a very narrow inquiry, Mr. President. And so by repeating this inaccurate notion that the court is calling on us for a clarification, I sincerely hope we're not trying to exert some sort of influence as this co-equal branch of government undergoes a consideration of this petition. We have the power to change the law, Mr. President, going forward, and in that regard, I don't favor this bill as a matter of policy. We also have the obligation to respect the law as it stands, in so doing, respect the separation of powers that are fundamental to our state democracy.
Senator Sorvag.
Mr. President, I would like to direct a question to the senator from District 20, if he'd be willing to answer it, and I'll state my question first, and they can choose. The senator has been a lead person on this issue from day one, starting long ago, and I give a lot of respect to him, and I know it's a very close and passionate issue to him, and he's worked hard on it. But for clarity, which is, we've just heard quite a few speakers talk about clarity, and we don't have clarity on the issue right now, because out there the media reported it wrong yesterday. They've reported it wrong, that we intend to take the money away from the striking beat workers or processing workers on the east side. If you sat in our committee, there was no intention to make this retroactive. It was not part of the discussion. It was made very, very clear that that to us is a settled deal. This amendment and this bill is from this day forward. And I would ask the senator from District 20, who sat in that committee and all that, to please affirm that.
Senator, do you wish to answer the question?
Absolutely. I couldn't turn down that good senator. I completely agree with him, and I have never made any statements to the contrary, nor would I. This body has been very clear from the beginning that it was never retroactive, and that has never been my assertion. So I believe that answers the question. I hope it does. Yes, I never inferred that, and this is not about going backwards. And it was, to my knowledge, misreported by one of the stations in the east, and it caused a lot of consternation that was undue. It's unfortunate, but mistakes happen.
Senator Miller.
Mr. President, this is about going forward, and this is going to be about what the state of North Dakota's policy is regarding labor dispute matters in the future. And what my opinion and definition of a lockout is when a organized group of laborers disagree and refuse to sign a labor contract. And when that occurs, there needs to be some sort of resolution before there is an emergency. And the way our sugar beet operators and refiners in this state work is they work on a very definite schedule, and they need to have their matters and affairs in order before they get into their campaign season. And that needs to be our policy as a state, to make sure that we are not inadvertently favoring one group or the other. And this provides a level field going into any kind of labor dispute.
Senator Anderson.
Well, Mr. President, let me explain quickly how I see this really would inject the state into a labor dispute. When you have a labor dispute, the workers have the option that they're always hanging out there as a carrot that we'll strike if you don't give what we want. And the employers say, well, you strike and we're going to lock out and shut down. And That's their care, so to speak. This is a way of telling them, the workers, that you don't have to worry because the state will take care of you. More than that, the ratepayers of North Dakota will help kick in to help you pay for benefits if you are locked out. That said, I think all of us are doing some political posturing here. I couldn't find any record in our committee hearings or discussions of a lockout ever occurring in North Dakota, which is a right-to-work state, where there are a high rate of employment in the state. I can't see a lockout ever happening. So it's just a matter of what kind of policy we want on the books. And we set out to do what we understood to be the long-standing policy of the state. Certainly was a policy of our committee that administers this program. And so this was just, we wanted to just have a clarification of existing statute, and that's what we attempted to do with this.
Senator Anderson.
Mr. President, I'm going to support this bill at the risk of revealing my political philosophy. That's encompassed in that North Dakota is a right-to-work state for good reason. I feel each of us should be employees at will. I feel that each of us should make ourselves so valuable to our employer that he would not want to fire us, lay us off, or lock us out. Thank you.
Senator Armstrong.
Mr. President, I guess I will also talk about our co-equal branch of government. As practicing defense attorney, dissenting opinions are something I really appreciate. I'm very rarely in the majority. And my understanding of the quotes that were given were not that it was the court order which said that. It was the Chief Justice of the North Dakota Supreme Court who said it in a dissenting opinion, of which there were two dissenting opinions on this decision, and the Chief Justice of the Supreme Court, in a dissenting opinion, did say it was a matter left to the legislature.
Senator Sinner.
Mr. President, my real problem with this bill isn't what most people have spoken about. My problem with this bill is that it gives the employer the right to lock out one worker for any reason he likes, and that person is and the employer can call this a lockout, and that employee does not get benefits. And I'd like the carrier to respond to that question, please.
Senator Unruh, do you wish to answer the question?
I'll have to ask the senator from District 46 to restate the question. I'm not sure there was one
Very well.
in there. Thank you.
Senator Sinner.
Mr. President, carrier from District 33. My question is, if an employer made a decision to lock out one worker, say that worker is me because I don't agree with the contract or the wage rate that we're talking about, can he lock me out for no reason and I cannot get benefit?
Senator Unruh, do you wish to answer the question?
I would love to be able to answer the question, but I don't believe that I have the knowledge to be able to do so. I apologize. Maybe somebody else would be able to.
Senator Klein, do you wish to answer the question?
I believe the senator from District 46 sat through that entire hearing. He would certainly been able to ask that question there. And I don't know why he may not have, but I don't think anybody in that particular committee that day asked that question. The discussion was whether or not we were providing the clarification that we've been talking about here today. Well, Mr. President, we had a separate bill. We had Senate Bill 2224. What would that have done? That would have included locked out workers in our unemployment. We voted unanimously to defeat that bill, and for a variety of reasons. But, Mr. President, we as North Dakotans, we as policymakers understood or believed that locked out workers were not included in unemployment compensation. Today, we are just clarifying that.
Senator Hogue.
Well, Mr. President, I don't believe it's part of this bill, but there is, in answer to the question from the Senator from District 46, there is a provision in the unemployment compensation statute that says that when the employer is simply using a pretext to terminate the employee for misconduct or for minor disagreements, the employee still gets unemployment benefits. And I'm not sure of the term, Mr. President, but I think the employee has to be terminated for something like gross misconduct. If it's simple misconduct like habitual tardiness or insubordination isn't of a material matter to the employer, those employees still get unemployment benefits. And that's probably the bigger rub. This lockout that we're talking about right now happens very rarely. The one that's happening out east has got our attention now, Mr. President, but the real rub in this act is that you can show up late every other day, and if it's a few minutes, that's not a level of misconduct that will support a deprivation of your unemployment benefits. So I think the answer to the question is if the employer uses some type of pretext where I disagree with you on a policy, you still get unemployment benefits.
Senator Mathern.
Thank you, Mr. President. I just wanted to add a clarification based on the comments made by the senators from District 2 and District 8. Just a clarification for the people in the chamber. These workers that were locked out all were willing to work. It was not that they walked out or were unwilling to work. They were all willing to work, and they were denied benefits. And I think that's an important clarification to make before this body.
Senator Murphy.
Mr. President, I just wanted to address a comment made by the good senator from District 2. It is true that the lockout we're talking about happened partially in my district, but I have to roundly deny any political posturing on my part. I don't know that the position I'm taking is any more popular there than here, but I feel it incumbent upon me, because I saw the destruction of communities economically and personal loss, that the fund would have helped temporarily. And again, it's a humanitarian issue for me, and I hope for everyone in here.
Senator Larson.
Well, Mr. President, I was one of these folks in my earlier life. I was in two unions. And in the state that I first was in the union of, you had no choice. You were in that union, you paid the dues, and you did what they got. They gave you the benefits that you got. And if I wanted to work there, I was in the union. It was understood that that's what you did. And when I came to this state, I was afforded the opportunity to be in another union. And I was in that union voluntarily. But then I decided I don't want to be in the union. But guess what? When I wasn't in the union anymore, I still got all the benefits that the union folks fought for. And so I was given the name of certain derogatory names because I was riding on the wagon and not getting the benefits. And now, with this situation, they knew, and I knew when I was in the union, that those benefits were provided. So now, I'm unemployed now if I was in this union that we're talking about, and then I get unemployment too. That, to me, it makes no sense. That I can get the benefits of being in a union in this state and not have to be in the union, and then get laid off or locked out, whatever you want to call it, and then still get unemployment. That just doesn't sit right with me. It does not make sense.
Any further discussion? Hearing none, Senator Dever.
Well, Mr. President, I hesitated to stand. First, I admire the senator from District 20, and I don't doubt his sincerity at all in this whole discussion. Prior to yesterday, I identified with the senator from District 20, and then he said there's two kinds of us, and I guess I'm the other kind. I started my business 35 years ago last week, Tuesday. Throughout this entire process, we've heard the plight of the workers, and I appreciate that. I know that it's difficult for them, but we haven't heard the side of the employer either. And it seems to me that the purpose in a strike is for the employees to get together, to walk out, to create pain for the employer, to induce him to their way of thinking, and then a contract comes together. Well, then it seems to me that the purpose in a lockout is just the opposite, for the employer to exercise in similar fashion leverage that he might have with the paychecks. So he asks them not to come to work, and he finds replacement workers, and they go forward, and somehow the purpose of that is to induce the workers to come back to the bargaining table and put together a contract. It's my understanding, even though we haven't heard from the employer, that they offered a pretty lucrative contract at that time. Well, Mr. President, I was one of the senators that spoke to the senator from District 20 yesterday after the session and said I didn't think that the state should be in the middle of it, and I don't. I think that negotiation should be between labor and management, and the state should stay out of it, but I think by providing the safety net to the workers, we stand in the middle of that negotiation going forward. So it is for that reason that I supported the amendment yesterday, and Mr. President, for that reason that I'll support the bill today.
Any further discussion? Hearing none, the question is on the final passage of House Bill 1112. Would the Secretary please open the key? All senators have voted. Any senator wishing to change their vote? Secretary, close the key. Final tally on House Bill 1112 reveals 32 senators voting yea, 14 senators voting nay, 1 senator absent and not voting. The bill is passed, and the emergency clause carries. Continuing on the 14th order.